Neil Shaw from the Law Office of Shaw & Associates, and I'm very excited that we're going to be meeting soon to discuss your personal estate planning. I often tell clients, advisors, or any referral source that the real goal of estate planning is to really get to two major variables. It's, this is what I have, and this is what I want to do with it. Whether you're planning for myself, or for you, Bill Gates, Warren Buffett, or the average family out there, if you really boil down to, this is what I have, and this is what I want to do with it, you can come up with a custom solution for yourself. So if you recall from our earlier video, and if you don't have our earlier videos, drop me an email and we'll make sure we get it over to you. But an estate is really everything that you own during your lifetime. At your death, it's called your estate. And an estate plan is deciding who gets what. Now often, what you'll see is this, or you'll hear this misconception out there, that if I don't have an estate plan, or if I don't have some comprehensive plan, the government's going to come in and take everything that I own. And for reasons that I'm going to explain in a second, that's just not true. Let's take our typical family situation. And in fact, let's take my family situation. In a typical family, or in my family, we have a husband, a wife, a son, and a daughter. Often, what people want to do is a plan that says, so long as I'm around, or so long as my spouse is around, I want my assets to go to each other. Meaning if husband's no longer around, assets should go to wife. If wife's no longer around, assets should go to husband. If neither of us is around, we want our assets to go to the kids. This is going to happen in most cases, even if there is no will, even if there is no trust, so long as there are not some extenuating circumstances, such as children from previous marriages, or will contests, and a whole host of other issues. Most states have laws that allow for this to happen even if there is no comprehensive estate plan in place. The downside is this will happen. So what do I mean by that? Well, if there is no planning, and the kids were to receive an inheritance here, the kids get it outright. What does that mean? Well, when they get it outright, it's in their account. It's on their balance sheet. It's in their personal financial statement. What we suggest doing, for children at least, and especially minor children, but really anybody, is inheritances should not be received outright, but they should be received in a bucket. And this bucket should be such that there's a lid on it. It's closed off. But what if you need to access it? Well, in order to access it, we're going to make sure that each of these buckets has a spigot that can be turned on and off. You're going to decide during the course of your planning who's going to be in control of the spigot. Why have a spigot? Well, if it doesn't hit their personal financial statement and the assets go into the spigot, it doesn't belong to them, but it's there for their benefit. If it doesn't belong to them, it can't be attacked. Who would be the ones to attack it? It could be litigators in the event of a lawsuit. It could be divorcing spouses. Maybe they're just not good with money and you don't want to give them that much control. Or maybe, like my children, they're young and maybe they shouldn't have that much control early on. If they're under 18, they're not allowed to get all that money outright anyway. It's going to be in some sort of court-mandated trust account until they turn 18. And then they fill out a couple of sheets of paper and they get it all. And I always say, I don't know about you, but when I was 18, if I had a couple of $100,000 or a couple of million in my account, I would have had a lot of fun, but I probably wouldn't be here recording this video today. So that's one thing. Now, assume that you want some of this. How are we going to get to this point? Well, that's where these brown arrows are relevant. These brown arrows represent a process called probate, or estate administration. So here's what happens. In my context, if I were to pass away, my wife, or whoever I appoint, is going to take my will to the courthouse and say, this is what Neil had, and this is what he wanted to do with it. That whole process is called probate. Typically, that process will take 9 months to 2 years. So it's a long process. Some states, like New Jersey, not so bad. Other states, like New York, kind of annoying and a little bit of a nuisance. So here's what we do to avoid that process. Oh, before I get into that, that whole process also very public, meaning if the whole world, your business partners, your friends, your neighbors, the average guy on the street, that nosy person who works with you, wants to see who got what out of this entire estate plan, they can because it's public information. So remember this closed bucket that we created for the kids? Imagine that during your lifetime, you decided that you're going to create an open bucket for yourself. And if you're married, you might create an open bucket for your spouse as well. Why do this? Well, unlike the ones that we created for the kids here, where there's a lid on it, this one's open. And that means that you can either put things in or take things out, no restrictions whatsoever. Because most people want to have that access. But if you were to become disabled, you can decide that your spouse will. And your spouse might have the inverse of that. Although people pass away, buckets don't. When one person passes away in this example, the bucket moves over to the next person. No court process involved. No public process involved. When the second person passes away, this transforms into this closed bucket for the next generation. There is no probate for the stuff that's put into this bucket during your lifetime. These can be changed at any time. They're revocable. These are created during your lifetime, as opposed to this one that's created at death. So it's living. And it's not a bucket, it's a trust. When you start this estate planning process, think of yourself at a fork in the road. And you have two different ways that you can pursue this planning. You could either have a will-based plan, which would have these arrows, but will still create these green buckets for the next generation, or anybody else you want to protect. Or you can go the revocable living trust route, which is basically saying, I'm going to create a bucket. And that bucket's going to be passed on from the next generation or to the next spouse, and so on and so forth with minimal effort. Do the work now versus save the work for later. So now you know the difference between revocable living trusts and wills. And that's really the foundational part of estate planning. I'm going to really quickly talk about estate taxation and how that works as well. And in the next video, we'll talk about the process and how we actually do this sort of planning. When somebody passes away, there's two authorities that generally want to look at taxation. And they want to see whether or not they can take a bite out of this estate, the amount that's being passed from one generation to the next. So in most cases, when a spouse passes away and another spouse receives it, there is no estate tax due because they have what's called the unlimited marital deduction. So let's just say, for example, there's $2 million passing and $2 million in this spouse's name, $2 million going from one spouse to the other. If we have a citizen spouse and this $2 million is coming here, there is no estate tax due. If somebody's on a green card or on a visa, different situation. We'll talk about that in person. But in this example, let's assume that they're both citizen spouses. This spouse now has a total of $4 million because there was no estate tax due. When the next generation inherits, that's when the drool starts coming out of some of these taxing authorities' mouths. That's when they want to look at this and say, yeah, we might be able to take a cut of this. Who are the ones that are going to look at it? The first is the IRS. And the IRS in 2014 says, if you have more than 5.34 million going to the next generation, we're going to take 40%. I'm simplifying a little bit for the purpose of this video, but there is a way for both these spouses to double up on that to make it a total of 10.68. Suffice it to say right now, use the 5.34 times 2, and know that the excess of that is going to be taxed at a clip of 40%. Not nice. The second authority is your state, most commonly New York or New Jersey. They're going to say, we're also going to take a look at this estate to see whether we can get a cut. New Jersey says, if you've got more than $675,000 going, we'll take our tax. New York has one that's actually changing every year until 2019, going up steadily. But this year we're using $2 million as a rounded up rounded down number. So New York says if you've got more than $2 million, we'll take our tax. How much is the tax for the state? It varies from state to state, but it's roughly about 15% in both states. These can also be planned for. The IRS got kind of smart, and they said, look, if we only tax people when they die, everybody's just going to give away their money before they pass away. So the IRS basically said, look, you could either die with that amount, or you can give it away during your lifetime. But if the total amount of wealth you transferred goes from one person to another person, not spouses, we're going to take this money. If you give it away during your lifetime, we'll call it a gift tax. And if you give it away at death, we'll call it an estate tax. Clearly, we wouldn't be doing our job if there weren't ways to mitigate this or avoid it altogether. And that's what we're going to talk about when we meet in person. Our next video, we'll talk a little bit about process and how we actually implement some of these strategies. So I look forward to seeing you on the other side. I'm Neil Shaw from the Law Office of Shaw & Associates, protecting your business, your family, your legacy.